serving as chair today. Our committee chair is under doctor's care, and from what I've heard from her husband, she is a terrible patient to put up with. And so we have a couple agendas changes. I do want to welcome Representative Miller, who will be replacing Representative Neighbors this afternoon. And I asked him if he would outrank Mr. Owsley or not. He said no, so he's just a peon on our committee. We'll mention that tomorrow we have probably a long agenda on the floor, but we have two items scheduled for tomorrow. One, an award for a student that will be here, which will be fairly brief, and then we have an informational hearing that's also going to be on Zoom, as I understand now. But we will plan on meeting, assuming that we can get here from not too late after the floor. So with that being said, the first item that was originally on the agenda, which was a hearing for the Senate Bill 232, has been postponed and will be reset to when our chair can be present. And we will move to final action on two separate bills, the first being Senate Bill 115, changing the lists of persons who are required to be given notice of the hearing on a petition for an independent or step-parent, private agency, or public agency adoption. And I'd ask our reviser if she could give a quick review.
Thank you, Mr. Vice Chair. Actually, thanks for doing my job for me. So Senate Bill 115 changes just the list of persons who are required to be given notice when there's an independent or step-parent adoption, a private agency adoption, or a public agency adoption. One of the highlights is that this is a Judicial Council recommendation. That's where the bill originally came from. And then some other points is that just because a person receives a notice, they're not necessarily made a party or granted standing based on receipt of that notice. And then additionally, the section provides a list of those who are not required to be given notice, such as a person whose parental rights have been terminated, or a person or agency that has waived in writing the right to receive the notice of the adoption.
Thank you. Are there any questions for the reviser? A couple points of information. This came to us from the Senate, and it passed out of the Senate by a vote of, I believe, 34 to 0. I believe it came to us. And we heard this on the 15th, and we had two proponents' testimony. We had no opponents and no neutral. And with that, I have a possible amendment that I'd like to bring forward. This is being submitted on behalf of our chair and is a procedural matter. As they hand out the information, if you go to page 2, line 15, the simple change would be, this act shall take effect and be enforced from and after its publication in the Kansas Register. We would take out the word statute book. So it is a publication date, making it more timely. Is there anyone wishing to make a motion on this amendment?
I move that we accept the amendment that's just been handed out for Senate Bill 115.
Do I have a second? Second by Representative Owsley. Any discussion or questions on this amendment? Seeing no questions, you may close.
I close.
All those in favor of the amendment adding the word Kansas Register, say aye. Aye. All opposed, nay. Ayes appear to have it. The ayes do have it. The amendment is adopted. Would now ask, are there any other amendments to be brought forward by anyone on the committee? Seeing no other amendments brought before us, would entertain a motion for to bring this to discussion.
Thank you, Mr. Chairman. I would move that we pass Senate Bill 115 as amended out favorably out of this committee.
We have a motion to adopt. Do I have a second? Representative Underhill is our second. Now, discussion on the motion to adopt. Do I have anybody? Yes, Representative Lewis.
Thank you, Mr. Vice Chair. I just have a question on line 27. It has to do with giving notice to the parents, presumed parents, and possible parents. What does anyone on the committee have an idea as to what possible parents would mean, does mean?
Representative Underhill.
Thank you, sir. I read it to be possible parents. The way I read it is, if representative next to me had a kid and didn't know if it was any number of us, it could be 2 or 3, so we were all notified, is how I read that.
Representative, go ahead.
Thank you. And I was on the committee, and we had a lot of discussion about that. Of course, the presumed parents are let's say the birth father, if they were married, that would be the presumed father. But then if the birth mother has given any other names of possible people, that would be on the list. In an adoption, she might name more than one.
Yes, Representative Lewis.
So who would be determining this issue of who gets notice? And I mean, they'd look at this list, but who would actually be giving the notice and have to interpret it?
Who would be giving the notice, or who would be deciding who gets notice? The court would be deciding, but it would be probably in the petition. The petitioners, who are the adoptive parents, would probably explain the situation with parents, presumed parents, or possible parents. And the judge would have the opportunity to look, and then as the hearing is set and to be finalized, the judge could ask any of those to be given notice or not.
Thank you. Are there any other questions? Yes, Representative Wagoner.
No, I did, on the final page 2, on the notice of hearing as far as not being required. So the people it's not required to be given as far as a person whose parental rights have been terminated by an order of the court, or someone who has waived in writing the right to receive notice, are they still ever notified? I mean, is it, they're not required to be notified, but is it at the discretion of the judge or somebody else, or are they forbidden to be notified? What is, can somebody explain how that part of it works? It's just, yeah.
Honestly, I have not worked with adoption notices. Representative Miller?
Well, that, excuse me, that language is there. I would say the intent of that language is to protect the validity of the adoption. It doesn't say you can't notify the person, but if they're on this list, they don't have any standing to challenge it for lack of notice.
Any further questions? Yes, Representative Carr.
Thank you, Mr. Chair. So just clarification on that particular topic. So does this mean that they have to be notified and there's a receipt of notification if the notification is by mail, or that they simply they're not required to be notified at all with respect to, for instance, the parent who has terminated their rights to custody?
Thank you. Now, my understanding was one of the reasons for this is so that we prevent having people show up after it's all done at certain hearings. And we could confirm that, Representative?
That would be part of it. I mean, if you look at who the two groups are, the first one, their rights have been terminated because of a court order. And then the second one, that person has waived, they've decided they don't want to have notice. And so they've waived it. And in my personal experience, they They do that for a reason. They don't want to know when the hearing is. I mean, that's part of it. But then also, how are they notified? I mean, which would be kind of Section E, gives the people who are supposed to be notified, it's personal service, certified mail with the return receipt requested, or some manner that the court might deem would be appropriate. That's for the people who are required to be notified. And then there's others that are notified just informally because they have a relationship with the adoptive parents, and it's, you know, they have that kind of ongoing conversation. So it just depends on the situation, but they're not required is the key here.
Representative Carr, does that help?
It does, but it poses another question with respect to those that that need to be or are required notification. Is there a particular time frame? I mean, I'm thinking that if it's a return receipt request on mail, and for instance, I'm in Topeka for that week, and I don't get that particular mail at home, does this process just take place without me? How does that?
Well, let me address just from my time with the sheriff's office. Usually the particular district court judge that we were working with would specify. And then the officer might make attempt to serve personally, and it comes back unable to make personal service, would request some other format, such as the registered mail, notification posted on the door front, depending on a specific judge. And it can take a lot of time. I do know that in cases where an example, one case I had, the subject was deployed. He was gone 6 months. And so the judge withheld any action until they came back. And the sheriff's office and the officers serving the notice is required to note on that. So that would be my understanding, and defer to an attorney here.
Thank you. So if you look at Section B on page 1, in this particular case, the statutes are clear that the person must be given notice at least 10 days prior to the hearing. And then that would be personal service or return receipt, so that the judge could see in an affidavit of notice, when you affirm that the person has received notice, you look at that green card and make sure that it was at least 10 days before. Now, the court can, in and of their own petition or in and of their own action, do something differently, but the normal way would be in person or the return receipt more than 10 days or more before the hearing.
And in my opinion, we need some more clarification there. You know, vacation is standard for most places. You'll get 2 weeks of vacation. 10 days, are these 10 calendar days? Are they, is it 10 consecutive days? Just, you know, my concern would be with this in its current form that there's a possibility that we're simply not giving someone enough time. And I understand that getting this done as expeditiously as possible is the concern of the court. My concern is just for that particular parent or someone who would require notification, that they simply don't have an ample amount of time from which to respond. Or at least that should be called out in this particular bill. Just an opinion.
Thank you.
Mr. Chair, if I may. So just, I agree 100% that the people who are required to be notified, it's super important that they're notified and they understand what's going on. So the return receipt like that, if let's say, if I was writing you a certified mail letter, it would be just to you. And if you don't sign for that, then you didn't receive it. And so that would not be considered adequate if you were on vacation for 2 weeks. So it has to be a signature of the person whose name is on the address of that particular notice. And then attorneys are required to file an affidavit that proper notice was given. Of course, a judge would look at that. And then the notice will say that you have, the hearing date is set for April 10th, for instance, and you have until 10 o'clock, at least in Sedgwick County, you have until 10 o'clock on April 10th to voice an objection, or you may show up at 10 o'clock on April 10th, but you can let the court know. It gives instructions on how to do that too. So it is really important that everyone who's determined to be notified gets notified. So thank you.
If I could also just respond on personal service from a sheriff's deputy, we were required to make notes and report back. So if you weren't able to locate, the deputy was required to make inquiries such as at a neighbor, checking on other information where that person might be. They actually put that down on their return before they could make a return unable to find. And that would go to the judge before they could request some other format. And we always would document, and that was in Wyandotte County. Thank you. Go ahead, Representative Carr.
Thank you, Mr. Chair. So am I overlooking the part where it states that that there must be a return of service notification, or does it not just say the notice of hearing on the petition shall be given basically a notice of at least 10 days? Am I missing that? Is it in here somewhere that states?
Could if I refer you to page 2, line 9, section E, notice of the hearing shall be by personal service, certified mail, return receipt requested, or in any other manner the court may direct. Notice given pursuant to this section shall not include a copy of the petition. And when I read this, any other manner the court may direct, there have been occasions I've had a judge direct that notice be placed on the doorway because you've confirmed they do live there and do respond. That was done in a couple of cases. But normally that return receipt requested has all that information that I just discussed. And that if a judge is not satisfied with the return, he can delay the hearing and would do so on his discretion.
Okay, so if my understanding of your understanding is correct, if for instance the service was not made, then at that point we're just left at the discretion of the judge.
I believe that they're all other manner, and that could be by publication in the legal notification for each county, and that depends on each county. So it's legally published in that newspaper.
Okay, I'm just basing it on what's in the bill, where it says notice of hearing shall be, as you stated, by personal service, certified mail, return receipt requested, or in any other manner that the court may direct. And again, I'm back at my original point. If we have attempted to make this service, but we've got no response, where does it state that the time limit? I mean, do we? I'm just uncertain, and to me, it doesn't clarify it. If we send it, return request, but there's no return that comes, do we just move forward in 10 days? That's where I'm confused. Does it say that, and I just don't see it?
I'd like to ask our revisor's office to take a quick look at that because you're more familiar with the legal status on returns. And this is a standing bill that we're amending what's already there, correct? So this is what's been in process before. This is not a new section, but Jesse.
Thank you, Mr. Chair. Yes, Representative Carr, so it is ultimately up to the judge in regards to if that personal service doesn't work the first time and that return service or that return receipt requested doesn't work either, then that is brought to the judge. And then I think an important part of this discussion is that from the time the petition is filed, they have to set the date of the hearing within 60 days. And that's in parent A on the front page. But then the last sentence there says the time fixed for the hearing may be extended by the court for good cause. So that also gives the court the discretion that it is possible it's the lack of notice could be a good cause to extend that hearing as well, the date of that hearing.
Okay, thank you very much. And thank you, Mr. Chair.
Thank you, sir. Representative Lewis?
Thank you, Chair. I was just going to respond, but I think it's all clear. It's all clear now.
Thank you very much. Representative Miller?
Thank you, Mr. Vice Chair. Yeah, I just wanted to punctuate as it regards to the notice. The only thing this bill says about notice is exactly what's in the law now. What the bill does, it simply expands the number of people who are to get that notice. So it's an expansion of the current law, but the notice, that's a difference between italicized language and that's not italicized. The unitalicized language on page 2, lines 9 through 12 is current law. That's how notice is currently giving. Nothing in this bill is changing that. We're simply expanding the number of people who are to receive the notice, as I understand it.
Thank you, sir. Other questions or discussion points from the committee? Seeing no further discussion, I would submit to the maker of the motion.
Thank you. I'll just quickly say, I think the way this bill is now organized is more clear. It delineates independent or step-parent adoptions, private agency adoptions, and then public adoptions. And then within each one of those types of adoptions, who needs to be notified. I think it's much more clear and should be helpful to our courts. And I move my motion.
We have the motion moved. No more further discussion. All those in favor of passing out favorably Senate Bill 115, say aye. Aye. All opposed, nay. The ayes appear to have it. The ayes do have it. Senate Bill 115 is passed out favorably. Thank you. Our second item for discussion is House Bill 2361. And again, I will ask our revisor's office to give a quick review.
Thank you, Mr. Chair. House Bill 2361 amends KSA 382700 or 2700, however you would like to say it. This is a statute that we've seen throughout the session, and it is a statute that directs the court on entering orders related to the custody of a child for the purposes of adoption. And so when the child is in the custody of the secretary, the current statute directs the secretary to first give preference of the custody of that child to a relative, and then second, to a person with whom the child has close emotional ties. What this bill does in regards to that specific section is the bill amends that those requirements are only to apply when the child has been in the custody of the secretary for one, only if this child has been in the custody of the secretary for less than a year. So child has been in the custody of the secretary for less than a year, the secretary is required to follow the statutory list of preferences. If the child has been in the custody of the secretary for more than 1 year, the secretary is not required to follow that list of preferences. Thank you.
Any questions for the revisor's office? Yes, Representative Wagoner.
Okay, Jesse, this seems in many respects very similar to House Bill 2299. So are they contradictory? Are they just saying the same thing? Or how do they compare?
Mr. Chair, Representative Wagner, so House Bill 2299, as further amended by the committee, has in B1, the preferences there are also subject to a year-long item. And then, so this, this does not add any further analysis to be made by the court after the 1 year, whereas House Bill 2299 requires a further analysis of, if they've been with a foster family for longer than a year, they may be considered, or if more than half a life, then the foster parents may be considered. So the real difference here is the 1 year, 2299 goes beyond that 1 year.
Any other questions for the reviser? Some general notes. We heard this back on February 15th for our hearing, and then it went through was sent into the Appropriations Committee and then back to us. At the time of the hearing, we had one proponent, and Sister Teresa was here, and then Laura Howard from the Department of Children and Families provided some written, and I believe also stood briefly. There were no opponents and no neutral testimony, and then we closed the hearing. Are there any amendments or motions at this point? Any amendment motions? Seeing no motions for any amendments, we'd move then to the bill. Do I have a motion for action on the bill? Representative Howell?
Thank you, Chair. I make a motion that we move House Bill 2361 forward for action.
Favorably for action?
Favorably for action. Thank you.
Do
Thank
we
you.
have a second? Second from Representative Pickard. Any discussion on this bill? Representative Wagoner.
I guess I would question the need for the bill. I mean, just given that we've passed 2299, which if the only change in this bill is this subsection shall not apply when the child has been in the custody of the secretary for one cumulative year or more. I mean, House Bill 2299 has basically the same language and kind of explains what happens if it's been 1 year or more. And so I guess I'm thinking that our action on 2299 makes this bill irrelevant, is my estimation.
Thank you. I'd just address one item, that this bill was originally requested by our chair, Representative Kincannon, and she would like to see this bill come before us for a vote. If that helps answer your question, sir. Any other discussion? Yes, Representative Neighbor.
What is the status of HB 2299?
Our reviser, could you look that up? I don't
Yes.
remember.
So 2299 is currently under the line. It was passed out by this committee for the second time the other week.
Do you agree with Representative Wagner's analysis that it does what this bill does?
Yes, Representative Owsley.
Thank you, Mr. Vice Chair. I think the committee would be in agreement that 2299 does cover most of what we see here in 2361, but then goes a little bit further. And 2299 had been under the line before, prior to turnaround, and was above the line for a day, was skipped over. The bill was referred back to committee to make adjustments. I can't say that those adjustments will satisfy the majority leadership on the House to bring that bill back above. So I would say that passing 2361 out of committee favorably is a good safe stop measure to make sure that the attachment situation can be addressed one way or the other.
Representative.
And I apologize because I am new to the workings of these pieces of legislation, but as I understand Representative Owsley's explanation, this one doesn't touch as many issues as the other one, and perhaps it might rise more favorably above the line.
Representative Owsley.
I think that's a safe interpretation of the situation.
Thank you, Mr. Chairman.
Any other discussion or comments on the Senate Bill 2361? Seeing no further discussion, Representative Howe, you may close.
Thank you, Chair. I close House Bill 2361.
Favorably.
Favorably for action.
Thank you. We have closed. All of those in favor of House Bill 2361 favorably for passage, say aye. Aye. All opposed, say nay. The ayes appear to have it. The ayes do have it. House Bill 2361 is passed out favorably. Thank you. Those are the only two items for today. You did receive your minutes in an email. Take time to look at those. At tomorrow's meeting, we will ask for an approval of the minutes from that meeting on March 15, and then also have the presentation and honor a young man. And then Wednesday's meeting, as you are aware, will be a joint meeting with the Juvenile Justice and Corrections Group. That's upstairs in a different building. It'll be on our list. 582 North needed some more room. And so we'll be joining that group, and their committee chair will be the chair for that meeting. Yes, we're meeting tomorrow. We have a youngster that's going to be receiving an award and then a presentation. And we will try to meet even if we are late getting off the House floor. Seeing no other business, we are adjourned. Thank you so much.